Good afternoon. I'm sorry that conflicting obligations prevent me from being with you at this important seminar on the TPP. I hope these few comments that I make on the impact of the TPP on copyright and internet policy are useful in your discussions. And I should say, feel free to get in touch with me if any questions arise from what I say today. I'm more than happy to answer questions. I'm easily found at the Sydney Law School. The impact of the TPP on copyright in particular, and internet policy more generally, can be summed up, I think, in 3 words: unbalanced, inflexible, and outdated. Now, these are not words that I would like to be using when thinking about rules that are meant to set an international framework for innovation policy for now and many years into the future. The TPP was meant to be a 21st century agreement. But the copyright rules in Chapter 18 were written mostly in the mid-1990s or earlier, so in the prehistoric era, as you might call it, of the mainstream internet. That's right, BG, before Google, and before YouTube, and Facebook, and Twitter, and Instagram, and many other of today's technologies. What we have is a 20th century text, setting the rules for 21st century technologies. Let me explain in a little more detail. The copyright text is unbalanced because in the 26 plus detailed pages dealing with copyright, out of a 74-page text on IP, most of the provisions that give rights or powers to copyright owners are mandatory, they're binding. The state does not have a discretion whether or how to introduce them. On the other hand, the provisions that are there for all the others, many stakeholders in the copyright system, whether that's individual consumers, businesses that use copyright content, educational institutions, internet intermediaries, the GLAM sectors, libraries, archives, etc. Those provisions are mostly non-binding. They're exhortations, you might say, to recognise other interests, pretty much unenforceable. Now, to be honest, this is actually an improvement. Early proposals from the US and past US FTAs have actually not included even these vague statements in favour of other interests in the copyright system. So this is a good thing. I'm really glad to see, for example, a recognition in the text of the importance of the public domain. I'm really glad to see a provision that says the parties shall endeavour to achieve balance in their copyright system. These can be really important, particularly when it comes to interpreting the text. So I think they're a really good thing, but overall they're relatively minor improvements in what is otherwise a very unbalanced copyright owner-oriented text. Copyright text is also too inflexible. Not completely, of course. Despite all of this text, countries do still retain some discretion in how they implement them and how they do innovation policy, of course. But the TPP text does set in stone many of the fundamentals and quite a few of the details of our current law. To give you some examples, it sets in stone our already excessively long copyright term in Australia. This is life of the author plus 70 years. A term that pretty much no one thinks makes any sense given today's technologies. You don't need life of the author plus 70 years for software. And few individual creators will benefit from that. Another thing that the text sets in stone is quite excessively broad criminal liability for copyright infringement, including a requirement that basically a single infringing copy made in a commercial context be a criminal act, regardless of how little harm, for example, it causes to a copyright owner. Now, I don't think for a moment that we're going to see every small business in Australia prosecuted for criminal copyright infringement, but the rules are there and they have a chilling effect. Again, we already have them in Australia, but locking them in here is a problem. The text also locks in pretty broad anti-circumvention rules. These are the rules that make it illegal to circumvent or hack digital rights management or access and copyright and copy controls, even if you're doing it for non-infringing purposes in many cases. Again, a few things that people like me were worried about that we might see in the text that would have been even more problematic have gone over the course of the negotiations. So, for example, there was in previous incarnations a rule about temporary copies. Basically made every single copy made in any kind of any kind of digital memory into a potential infringement. And that was a silly rule. And it's gone in the final text, and I think that's an excellent thing. Finally, the text is outdated. As I said, many of these rules were originally written in the mid-1990s, 20 years ago, right? You know, several, or I don't know how many lifetimes that is in internet technology terms. For example, the safe harbour rules and the anti-circumvention rules were passed by, are based on frameworks that were passed by the US Congress in 1998. That's the year that Napster was invented. I don't know how many of you remember Napster, one of the earliest file sharing technologies. It's a very long time ago. Again, piece of good news. There's no rule that requires termination of internet service to repeat infringers in this text. That's an improvement, at least we've moved on from that. Now, you will hear proponents of the TPP IP rules say that it's fine because it doesn't require Australia to change its copyright law. That's probably true with the exception of the safe harbours, which we do need to introduce. But, we should have introduced those a decade ago when we did the US FTA. But, putting that to one side, it's actually not fine just to say that the rules reflect current law. That would only be fine if we thought Australian copyright law was currently perfect and would remain perfect no matter what happens in terms of technology or business models in the future. Right? Copyright is innovation policy. It needs to be flexible. And the fact is that the TPP is going to make reform harder. Not impossible, of course, but harder. And copyright reform is already hard because of all the vested interests. The introduction of investor-state dispute settlement will have an impact here. But I know that someone else at the seminar is covering that off. And by the way, I should also underline that while changes to Australian law won't be necessary in copyright, the TPP will require changes in some of the other countries in their copyright laws. There are countries that will have to extend copyright term with all of the economic and social costs that involves. That will have to change their anti-circumvention law like we did a few years ago. Again, that's a problem. For countries that have not already got a US FTA in place, these rules are going to be pretty significant. When we did the Australia-US Free Trade Agreement 10 years ago, we had to enact massive changes to our copyright law, and we're still feeling some of the effects of that. From an internet policy perspective more broadly, I should say that the copyright rules are not the only ones that matter. Right? I'm sure many of you are also interested in questions like, does the TPP impact on data localisation rules? Policies that might require data to be hosted in Australia rather than sent overseas. Does the TPP stand in the way of putting in rigorous privacy standards, including on services that may transfer personally identifiable information of Australian consumers overseas in the course of providing services? Look, the rules here are complex and worth more time than I have. The e-commerce chapter is the critical one here. Fortunately, someone else has published an analysis of this, and I do recommend you go and read the analysis published jointly by Public Citizen and the Canadian Internet Policy and Public Interest Clinic that goes through the highlights of the e-commerce chapter. It's worth a read. There are some restrictions. Look, overall, we're still at the very beginning of understanding the TPP and its impact. There are hundreds of pages of substantive text, thousands of pages if you include all the annexes. But from a copyright and internet policy perspective, sure, the text is better than it could have been. It's more balanced than some of the early proposals. Some of the nasty stuff has gone. But it is still an outdated, unbalanced, and insufficiently flexible and fundamentally 20th century text. And I think, given that we were concluding this in 2015, and we were trying to set rules for the future, the Asia-Pacific region deserved better. Thanks for your attention, and I hope the seminar goes well.